Hello again, and welcome to the second part of our presentation on post-conflict political processes. And in this second segment, I am going to be talking about institutions and initiatives that have their origins in the effort to apply international criminal law and achieve what is called post-conflict justice. These are probably the initiatives that are most prominent. They have certainly received the most funding and have been active for the longest time, and are the most discussed. What are we talking about here? We're talking about the International Criminal Tribunal for the former Yugoslavia, which is the first international tribunal to be established to try crimes against international humanitarian law, and to do so under the auspices of the United Nations with an effort to engage in as complete investigation as possible and to provide a good quality of fair trial in all instances. The ICTY was formed in order to compensate for what was seen as the failure of domestic legal institutions to prosecute these crimes, and a part of their expansion was to encourage the formation of special prosecutors and special chambers for violations of international humanitarian law in all of the states that were involved in the conflict in the former Yugoslavia. This has been done in all of these states. What I think we need to understand about this initiative grounded in international criminal law is that this was created as a compromise. The International Criminal Tribunal for the former Yugoslavia was created by a United Nations Security Council resolution in 1993. That is to say that its formation was contemporaneous with the violence as it was occurring. And it was meant to act as a deterrent to the commission of further crimes. We can certainly argue that it was not terribly effective in deterring crimes. But what may need to be noted is that there were other ideas about how crimes could be deterred or prevented that included things like international military intervention. The political will did not exist among more powerful states in the Security Council and in the United Nations for military intervention, so they got a tribunal instead. That is to say that this was a compromise. It represented the limitations of what powerful international actors were willing to do, and we can talk about what they have achieved. The tribunal, in 17 years of experience, has investigated a large number of cases, prosecuted a smaller number, and produced a record that could be described as mixed. That is, they both established some major precedents in international criminal law and produced some decisions that were controversial, especially acquittals that related to questions like command responsibility, to the involvement of international actors and cross-border activity in the commission of crimes, and to questions of overall responsibility for the inspiration and implementation of violence. We could say something similar about domestic prosecutions. Some states have been more successful than others. For instance, Bosnia and Herzegovina has tried a larger and more diverse number of cases than other states in the region. In general, the experience of domestic prosecution has been spottier. The experience that has been built up has been smaller. The selection of cases is more clearly politically based, and the record that they have produced judicially is even more mixed. So with a record like this, it's possible to offer some evaluations, some critical evaluations of initiatives in criminal law. Let's begin with some positive things that can be said about them. The first positive thing is something very basic, but it's so basic that it's very often forgotten, and that is that a precedent was established for the prosecution of these types of crimes at all. This had not been done, at least not by legitimate legal institutions, anywhere in the world. This was the criminal tribunal for the former Yugoslavia was the first international criminal tribunal to be formed by the United Nations, the first one to apply the Convention on Genocide from the time that it came into force in 1951. So one of the things that we can say is a positive contribution of these initiatives is that, as critical as we may be of the scope and scale and of the effects of the action that these institutions took, some action was taken at all. And this is not a minor accomplishment. It's frequently overlooked. Another contribution that we can talk about is that it's possible that the greatest contribution that was made by legal institutions was made not by the lawyers on either side or by the judges hearing the cases and their decisions, but by the investigators who produced documentation of events, produced testimony from witnesses, from both perpetrators and from victims, creating what is probably the most complete record of instances of large-scale violence that exists in human history that can be useful for a number of things, including further research and prevention, but also for addressing the question of denial. And finally, it's worth pointing out that several of the cases that were heard as a part of these processes were landmark cases. It was through these processes that we had the first findings indicating that a genocide had occurred, that is, the first applications of the Genocide Convention, so the first genocide conviction to be handed down under the Genocide Convention was not by the Tribunal for former Yugoslavia, but by the Tribunal for Rwanda. That was the Akayesu case in 2006, I believe, and also the first findings that defined sexual violence as a violation of international humanitarian law, that is not as something that occurs incidentally to a conflict or to military action. So these are what might be regarded as some of the chief accomplishments of legal initiatives. What were some of their failures? Probably one of the first critiques that is made is that the scope and scale of prosecution was limited. It was inadequate to the scope and scale of the crimes that were committed. This is a critique that might be taken with a little bit of reservation in the sense that it is never possible in any conflict to prosecute or to convict all of the people who committed violations. Choices have to be made, and very often these choices are made for what might be called political reasons, that is, to demonstrate a point or to show the scale of command. Nonetheless, as in every post-conflict justice instance, the scale and scope of prosecutions was incomplete, and this is a source of frustration. A second problem is that because of the way that these institutions were founded with considerable international involvement, the legitimacy of the legal institutions has never been uncontested and has never been unproblematic. And although this question might have been addressed and possibly resolved as a legal matter, as a political matter it is not resolved. And this means that that in the domestic political environments, the meaning and importance of their findings has always been subject to a certain level of doubt. Third, if we talk about the judicial record that is created through prosecutions, there are a number of convictions that are probably important. There are some convictions that can be criticized, particularly for, again, their limited scope, and a number of acquittals are especially controversial because they cast doubt on the character of the conflict, the international nature of the conflict, and questions having to do with the responsibility of senior officials, especially political and military officials, some of which have been reduced in verdicts to questions of intent under legal theories that have been subject to a lot of criticism. Another criticism that's offered has to do with, at least in the first period of these institutions functioning, fairly weak communication with the publics of the region that were their purported clientele, with the result that a lot of what happened before legal institutions was not well enough known and was not understood, and a lot of the argument, much of which took the form of abstract legal argument between the law professors who were acting as prosecutors, the law professors who were acting as defense, and the decisions made by the law professors who were judges, were not understandable to a wider public and not communicated to a wider public in a way that made their meaning clear. But one thing we have to say about all of the criticisms is that at least part of them are a consequence of the fact that expectations were attached to these legal initiatives that were probably unattainable. That is to say, there was an expectation that a very meaningful intervention would be made to establish responsibility for crimes, that these would contribute to political and social and cultural processes, that would contribute to the development of peaceful relations and reconciliation. And in retrospect, it was always very unlikely that cases argued before a court of law would have these effects, in particular without the involvement of institutions in the society to help to create that effect. So when we talk about failure, one of the things that we need to consider is that the things that we consider these institutions having failed as done might have been impossible to achieve in the first place. Um, I want to talk about a further mechanism of the tribunal, and especially the tribunal, but to a lesser extent, domestic political institutions, and that is the operation of conditionality. And what conditionality means this is that something called cooperation with the establishment of justice in the period after the conflict was tied to political goals of the states of the region, including recognition, acceptance into international organizations, eventually into the European Union. So progress on these fronts was tied to what was seen as progress in cooperation. And to a degree, the imposition of conditionality had some of the intended effects. That is to say, if states were asked to arrest and to deliver people charged with crimes for trial, they generally did it. If states were asked to provide information that could be used in the preparation of cases for trial, they did it less often, but did it more often than not. Sometimes they found reasons not to do it, such as state security or secrecy. But there were also some unintended effects. And what the unintended effects have to do with is the way in which cooperation was defined. Because if cooperation means the delivery of suspects when requested and the delivery of evidence when requested, what this means is that the role of the states of the region in cooperation is fundamentally to act as travel agencies for indictees and postal services for evidence, and this separates off then these formal requirements from a lot of informal requirements that are much more important, including educating the public and engaging in dialogue with the public about the nature and character of the conflict. So while conditionality had some positive intended effects, there were some unintended effects that can be summed up as separating the processes of achieving justice from the social processes of understanding and dialogue that were occurring in the states involved. On balance, then, if we are to offer an overall assessment of criminal law-based institutions, and on the title in the slide here I put the Tribunal, but it's not just the Tribunal, here's what we can say. First of all, we should not overlook the major contribution, which is the fact that anything was done at all, regardless of any debates that we might have about the adequacy of what was done. Second, the documentation that was produced through trials, and this is regardless of the fact of whether we might like what the judges in the trials decided or not. This is documentation that provides a permanent and well-resourced record that shows us about the processes of violence, helps us to understand how violence takes place, and provides a permanent answer to anybody who might deny that crimes took place. There were also some unintended effects that might not necessarily be entirely negative. One, by relying solely on the formal processes of criminal law, the limitations of this approach were demonstrated. And that sounds bad, but it leads to some creative efforts that occur in the period afterward. Another of these is that by engaging in communication with the public in a limited and largely ineffective way, the importance of communication with the public was demonstrated. And this sounds like a backhanded compliment, but it's not the case. Every subsequent international legal institution that was formed to deal with crimes committed in the context of conflict included features like separating the process of fact-finding and of telling the story of the conflict from the process of prosecution, of locating the institutions that did the work of prosecution in the states over which they had oversight to encourage communication, and of including not only as defendants and as attorneys representing the defendants, but also as judges and investigators and administrative personnel, people from the states over which these institutions had oversight in the work of the tribunal. And finally, what we might want to note is that some of the limitations of legal efforts were not the fault of the legal institutions involved, but came from outside of the legal institutions. And these included not only unrealistic expectations attached to their work, but also the ambivalent attitudes of states involved toward the process of achieving justice. And this includes both states involved in the conflict and states from outside intervening after the conflict, and the weakness of political will on all sides. That is to say, to the degree that we want to talk about the failure of initiatives grounded in international criminal law, not all of these failures are failures of the institutions themselves, but apply more to the context in which their activity took place.